Do you know the Daniel Law? With more than 60 years of experience in the international intellectual property market, Daniel Law is not only one more IP law firm. Our outcome, our legally wise business solutions, can help you succeed in your initiatives and grow your business. With teams that work in cross-integrated functions, Daniel provides all kinds of services in intellectual property in Brazil and Latin America. If your business depends on intellectual property assets, come to Daniel. This webinar was produced by Daniel in association with Marval Ofahel Mairal from Argentina, Meritzi Ramsbottom and Foster from Canada, Sargent and Cran from Chile, Olarte Mouro e Associados from Colombia, Corral Rosales from Ecuador, Olivares from Mexico, Fernandes Seco e Associados from Uruguay, and Nob Martins from the USA.
Hello, everybody.
Hello.
I'm Roberto Ribeiro from Daniel Law Firm in São Paulo, Brazil. I hope you all guys are doing well in this difficult and strange times of pandemic. On behalf of Daniel Law and our law firms, we want to welcome each one of you to this webinar about compulsory license in the Americas. Although the subject matter or the title is compulsory licenses, we could not leave aside other relevant topics nowadays. So besides compulsory licenses, we will also share with you other relevant insights about, for example, how the patent offices and the judiciary are responding to the current challenges due to COVID-19. Not less relevant are the conditions for obtaining patents for second medical use of known substances. Everyone has been following by the media all the efforts that are being made to find a prevention vaccine or cure for treatment for COVID-19. Of course, the repurposing of new drugs is an intelligent shortcut to reach out to a final drug that really works instead of starting the development of a new drug since the very beginning. For those that are more familiar with the pharmaceutical markets, it is known that a new drug may take at least 10 or 15 years to be developed and requires an amount of investment of around $1.5 to $2 billion. We can't spend that money, and even more important, we can't wait that long for a new drug. So repurposing new drugs is really a great option. And among those, just to cite some examples, we have heard about hydroxychloroquine or hydroxychloroquine combined with azithromycin. We have also heard about the remdesivir from Gilead and many other options. Around 400 tests are being done worldwide in order to find a treatment. So I wouldn't be surprised if any of those companies would be interested in seeking for a second medical use for a known substance. So we will share the conditions for obtaining those patents, whether or not those patents are possible, what are the hurdles that the companies should overcome in order to obtain those patents. All these matters will be discussed in a very broad territory. Today, we will have coverage from major markets in Latin America, as well as US and Canada. We have adopted this broad territory as a landmark for us today, because we think it's important to provide in-house counsels and law firms working in this subject matters with the broadest possible view. Of course, because of the complexity of the matter and the broadness of the territory, we will not be able to exploit each and every detail during these 2 hours. So if there are any further questions or consultations, those of course can be done after this seminar. In terms of benefits that we expect to deliver for in-house counsels, as I said, the webinar concentrates in one-stop shop information about 9 countries in only 2 hours rather than sending hundreds of emails for a week or even more. And for law firms and other clients, universities and IP professionals, we expect to be capable of delivering the same or similar benefits. In terms of structure of the event, we will have the event split into blocks. So after this, my introduction, there will be a series of presentations made by highly qualified practitioners in all the countries. These presentations will be done country by country and in alphabetical order of the countries. After all presentations are done, we will then open a Q&A session. Your questions are more than welcome to be received by the chat function of the Zoom and will be read out loud by our colleagues here in São Paulo. Also important to mention is that this webinar is being recorded and will be made available through our website, www.daniel-ip.com, or by email, helpline@daniel-ip.com. So with no further delays, I would like to introduce you our speakers today. As I said, in alphabetical order, we'll listen to Christian Daniel Bitel from Argentina, from the law firm Marval O'Farrell Mayrol. Then I'll speak on behalf of Brazil. Then we'll have Canada, Andrea Merisi from Merisi, Ramsbottom and Forster. Then we'll have Chile, Juan Pablo Egaña from Sargent and Graham. I'm not sure Juan Pablo was able to connect. If Juan Pablo, for any reason, didn't connect, we'll skip to the next, who will be Alexander Agudelo from Colombia, Lartin Mori. Then we'll go to Ecuador. Maria Cecilia Romolero will speak on behalf of Coral Rosales. Then Mexico, Alejandro Luna will speak on behalf of Olivares. Then United States, our colleague Dan Altman will be speaking on behalf of Node Martins. And finally, but not less important, we'll be having Uruguay with the presence of our colleague Agustina Fernandez Chambruno on behalf of Fernandez Seco. So one last disclaimer, you guys probably have attended, ladies and gentlemen, several webinars in these times. We expect that the technology favors and works well. We have a whole team of IT and the back office working furiously to make this event run smoothly. So if there is any problem or difficulty in connection, please be sure we'll try to fix it as soon as possible. Stay with us, don't disconnect, okay? All information shared in this event express opinions of the respective speakers and should not be taken as legal advice. If needed, legal advice should be sought on a case-by-case basis. So I would now ask Anna to skip to the next slide, please. And invite Christian Daniel Bitel from Argentina, Marval O'Farrell Mayrol to open the event. Please, Christian, the floor is yours.
Okay, thank you, Roberto, for the introduction and of course for the opportunity to be a part of this webinar. Well, you know, as a result of the current health crisis and the economic pressure that this puts on governments, many of them have been paying attention to the possible flexibilities that could be applicable to patent rights. In this regard, patents do confer to the title holder the right to exclude others from making, using, selling, importing their protected products. But in any case, all IP regulations include exceptions that are to be applied in very specific circumstances. In this regard, you can move to the first slide, please. In this regard, the Paris Convention already allows their members to take legislative measures to provide the grant of compulsory licenses to prevent abuses from patent owners. More recently, say, the TRIPS agreement also includes some exceptions to patent rights, again, in very specific and particular circumstances. And in line with that, the Argentine patent law accepts that and also considers the possibility of compulsory licenses, again, in particular circumstances. And in the particular case of Article 45, it talks about compulsory licenses in the case of sanitary emergencies. Even though this is in our patent law, which was passed shortly after the TRIPS agreement assignment by Argentina, no compulsory licenses have been ever granted. So we have no experience with particular compulsory licenses. Then we can move to the next one. Even though the patent law does not specify a particular process for the grant of compulsory licenses, it is clear that in any case it should be issued by the national executive power, and that due to the considerations, the specifics of these measures, the Ministry of Economy and the Ministry of Health, as well as the Patent Office, should be involved in the process. It is also clear that the patentee should receive a reasonable compensation. Again, nothing's written about that, and I guess that's something, I mean, a lot of discussion would take place in case of a compulsory license in this regard. And finally, since this is a measure for a very specific circumstance, the scope and duration of the measure should be limited to the duration of the sanitary emergency. In the case of Argentina, the Argentine government, I would say prophetically, passed a law in this last December, well before we were really aware of the importance this coronavirus pandemic would have and the impact it would have. And it was basically due to our national social and economic emergency, which predates the pandemics. That law states that the Ministry of Health is entitled to monitor the pricing of pharmaceuticals and to consider the direct imports and compulsory licenses in case it is detected that there's no adequate access to medicaments by the population. So at some point, a sanitary emergency was already declared in December last year. Again, in March this year, now due to the COVID pandemics, the executive power issued a decree declaring and extending the sanitary emergency for the term of 1 year. So the point is, we can move to the next one. So the current situation is that the first step necessary for the grant of a compulsory license is already taken. So the sanitary emergency has been declared already. However, there have been no requests for them. We are not aware of any initiatives in this regard, neither from the government nor from particulars. And as I mentioned before, a compulsory license has never been issued in Argentina. At this point, I would like to point out, and even though I personally agree with Roberto regarding the importance of new uses of known compounds. The current situation in Argentina is that neither methods of treatment nor second medical uses are allowed by the patent office. And this is a personal opinion, I consider that any compulsory license that could be discussed could revolve around devices such as ventilators, masks, or pharmaceutical compounds. And in any case, we should think of devices or compounds that have already granted patents. I would not expect the Argentinian patent office setting a fast track or the like for COVID-related inventions in this current situation. As regards to the status of the patent office is currently, physically closed. However, they are working remote. It is possible to file applications online, to file responses to office actions. The patent office is currently working on a notification system so that we will be able to be served notice of new office actions. That's not currently possible, but coming soon in the next weeks. And the point is that all terms have been suspended since March 13, currently until May 24. That date is being updated every 15 days. So we don't know the exact final extension. As regards to the judiciary, the Argentine federal courts are, which are the ones that hear patent cases, are in an extraordinary recess since March 20. All judicial terms have been suspended also in a similar fashion as the patent office. And even though they are suspended and the judiciary are in recess, it is possible to request an exception to that recess on the grounds of urgency. So in case of an infringement or in case of a case that is already being prosecuting, it is in principle possible to file a request for an exception to the recess to get a response. And so with this, I pass the word to Roberto, who will tell us about Brazil.
Okay, Christian, thank you very much for the clear explanation. I will now share with you, colleagues, an overview about Brazil. So Anna, if you could please move to the next slide. Yeah, the next one, please. Perfect, thank you. Well, I'll start my presentation here discussing with you the judiciary and the patent office, how these two important institutions are working and handling with the challenges of COVID-19. Well, as for the PTO, I would like first to open sending my best congratulations to the patent office. The congratulations are especially because, number one, all servants are working remotely since a long time ago with no loss of productivity. In some cases, there was even an increase of productivity. This is something I have heard from the director of patents. So everyone is really complemented here by this excellent performance. The program that one of the most, if not the most important one program nowadays in the patent office, that is the program to reduce the patent backlog, is ongoing normally. For those who are not familiar with this program, a few words saying that it takes into account patents filed until a certain point in time of late 2016. These patents are being examined on a different fashion, I would say, as compared to the traditional exam, in the sense that the office actions are being sent based on previous former examinations made in other countries like US and Europe, for example. And if the patentee accepts the office action to set the claim set according to the foreign patent that was already examined and sometimes even granted, the patent is immediately granted. The target of this program is reducing not less than 80% of the backlog within 2 years. So if all goes well and works as we expect, and we do have reasons to believe that this will happen, in maybe 2 years, we will be having a very insignificant patent backlog. And importantly, we will be having patents being granted in Brazil in a very expedited fashion, maybe 1.5 years or even less. So I think that's really something remarkable, and it's important to give room to this topic. All deadlines for existing processes were postponed to 31 May 2020. The resolution saying it was published yesterday. As I said, INPI, that's the Brazilian Patent Office acronym, continue working remotely, and there's no clarity about when they will back to work, as there's no clarity for us as well. So, and new applications can be filed normally, however, all of them virtually. So since a long time ago, the Patent Office has adopted the e-filing system. So anyone who wants to file for a patent or a trademark can do it remotely, and this system has been of great benefit because it allow everyone to file for patent applications and trademark with no worries. As for the judiciary, we still have some lawsuits prosecuting paper. These lawsuits were filed back in 2000, or in the beginning of 2000, when the process was still in paper. And the terms are suspended until May 15. We do expect that this term may be extended. However, for suits filed electronically, the terms resumed on 4th May, except for the Supreme Court and Electoral Court, which details are not important for this webinar. And oral hearings and virtual judgment sessions are working normally here. We should say are working normally, however, all of them virtually. There are no oral hearings in person. All of them are happening by video. In case there is an infringement of a patent or trademark, the lawsuit might be filed before a civil court in Brazil. If it includes an allegation of nullity, should be filed before a federal court as well. We have the bifurcated system in Brazil, in which nullity and infringement run separately. However, fortunately, no big issues regarding infringement lawsuits, including those seeking injunctive measures, either inter partes or ex parte, can be filed and processed normally. Just to say that there is one limitation that came up after the COVID, that the personal hearings are not allowed, and these personal hearings used to be very useful, especially when we file for an ex parte injunction. It is common practice when, or as you file for the ex parte injunction, to request a personal hearing with the judge to explain the urgency, the importance, or explain any complexity about the matter that is under discussion. And these personal hearings are no longer allowed. Jumping to the next topic. Patenting second medical use in Brazil. As I said, this subject matter is gaining traction, especially because of the possibility of using known drugs to treat the COVID-19. And differently from Argentina, in Brazil, these kind of patents are allowed. However, it's important to learn a little bit more about some details around these kind of patents. The first thing I would like to share is that the Intellectual Property Law 9279 does not explicitly foresee the category second use patents. And the IP law does not say it's forbidden to second use patents. What you have to take into account to seek a second medical use patent is the conditions for any other patent, that is literally novelty, inventive step, and utility or industrial application, combined with Chapter 9 of the guidelines for examining patent applications in Brazil, which sets about 10 or 12 conditions that should be observed in order to draft the claims and set the correct examples and technical or scientific information that should ground the new invention. Besides the IP law and the said Chapter 9 of the Guidelines for Examination, there is an important jurisprudence that should be observed. Here, as you can notice, I have said that is non-binding jurisprudence because Brazil operates under the Roman law and not all jurisprudence is binding, and this one is not binding particularly. This jurisprudence, to make a long story short, says that in a case filed by Eli Lilly versus the Patent Office, Eli Lilly had filed a patent in 1996 for the substance atomoxetine. This substance was supposed to treat attention deficit hyperactivity disorder, ADHD, and was previously known for urinary incontinence. So the second use for ADHD was different from the first one. Some prior art was brought by the patent office, and the patent office said that the patent could not be granted because the prior art was relevant to the new use against ADHD. And after the discussion at the trial level, the case went to the appeal level, and the final decision was issued at the appeal level, denying the patent, but not because it was a patent for second medical use, but because the evidences that were put together to show the surprise or novelty of the new use were considered not enough, because in the words of the Chief Judge Abel Gomes, judge in the case, the invention started from something already known, so more robust evidences should have been put together to make evident that there was scientific work that justifies a patent. So lesson learned in this case, if you ever intend to file for a second medical use patent in Brazil, I totally recommend reading, of course, the IP law, the Chapter 9, but not only that, also read the case Eli Lilly versus the PTO, or consult with us and we can help you on that, of course, but reading those three cases is important to learn the information that should be set together. Finally, it's also to be noted that whenever the patent for second medical use is granted, there is the claims that are allowed are claims of the Swiss type, which are claims that say use of substance X to manufacture a medication to treat the disease Y. And of course, the coverage of the second medical use does not encompass treatment or the substance per se, which is already known. So those are the most important aspects that I can share with you about patentee second medical use. Now turning to the compulsory license topic. Well, compulsory license is a subject matter that always gives a lot of discussions, no matter in which country it happens. All over the world are around 160, more precisely 156 countries that have in their respective legislation conditions for compulsory license. In Brazil, as you probably know, according to our constitution, federal constitution, health is a matter of universal right and is a state duty to provide health treatment for everyone. Compulsory licenses are provided for in the Paris Convention, as well as in the TRIPS agreement. Having had some adjustments, I would say, by the Doha Convention in the early 2000s, giving some flexibility or safeguards, generally speaking. One of the flexibilities provided for by the Doha Declaration was that the TRIPS should not prevent members from taking measures to protect the health of their population. Compulsory licenses are allowed in Brazil under several conditions. Those conditions are set in the Brazilian IP law from Article 68 to 74. And the conditions cover, for example, abuse of patent right, abuse of economic power, non-use of the patent, commercial use that does not meet the market needs, dependency on another patent to exploit the patent, etc., etc. But the main one that really concerns us now is provided for in Article 71 when the case is a matter of public interest or national emergency. Of course, as in many other countries, Brazil is under an emergency situation, and the compulsory license in Brazil are provided for in Article 71, as I said, insofar as the patentee or licensee does not meet the necessity of the market. That subject matter was further regulated by two decrees, the 3201 of 99 and 4830 of 2003, which further regulated the previous decree of 99. What we have to keep in mind, basically, is that there is the need of a previous negotiation between the government and the private entity having the patent. The license is for a limited period of time and non-exclusive use. And there is no authorization for sublicense. Further, those further decrees regulated other conditions under which the license could be applied, for example, for importation of the product. And last but not least, I would like to mention that between late March and early April, 3 bills of law were presented in the Congress lower house. These are the numbers in the slide, 1320, 1462, 1184. And to summarize the main aspects that they regulate, they say that the compulsory license in case of national emergency should or could be granted regardless of the patentee or licensee meeting the necessity of the market. So that's I would say, the most important change in the existing legal scenario. I do think that these 3 bills of law are really unnecessary, but they tend to come into force in order to create more favorable conditions to have compulsory license granted. That's all I had to share in this moment. I will like to thank everyone for the attention in those minutes, and I will now turn to our colleague Andres Merisi from Canada, representing Merisi, Ramstone, and Forster. Andrea, can you please start your presentation? Thank you.
Thanks, Roberto. So hello to everyone. Thanks for joining in. I'm happy to be participating in this webinar and sharing some information about Canada and how we're dealing with this at this end of the Americas. And if you want to move to the first slide, I'll jump right into deadlines and extensions going on with the Patent Office. In fact, applies to industrial design and trademark as well. So as it stands, the Canadian Patent Office has been operating pretty much as usual. Cases are being examined remotely, as they already were in many circumstances. We're seeing some delays on some procedural aspects, like ordering certified copies of documents and these things. But even there, we received recent news that they're going to start to act on those tasks as well. And so really, practice hasn't really changed here. We're still getting new office actions. We're still prosecuting online, and you know, business as usual in a certain extent, if we can say that in this context. However, the deadlines were formally extended, so any deadline falling between March 16th to May 18th were extended to May 19th. I received an unofficial notice yesterday that that deadline would be further extended to June 1st. I wonder if that may be the last extension we get, but for the time being, that hasn't been formally announced. I'm expecting that later today. That being said, given that the Patent Office is operating as usual, we haven't taken advantage of that. I would generally suggest that we don't unless absolutely necessary, simply because there's usually ample time to do what we need to. And so that is what we can deal with. And again, that applies to patent, trademark, industrial designs. And so the other thing to think about, one of the reasons to maybe avoid these deadlines extension is that they don't necessarily apply to every single aspect as one might expect. And so a few examples, the Canadian grace period with respect to inventor disclosures, confidentiality period, deadlines for appealing to federal court, deadline for filing a divisional application. Those were not extended. And so it's important to be careful not to take a blanket approach to these kind of extensions. And the other aspect that I'll turn back on my last slide, when we're considering about innovation in this context, the governments are moving quickly, the market's moving quickly, and it may be important for innovators in this space to expedite examination for certain cases. And we have a very efficient process for doing that in Canada. The fees are nominal. And you can expect, if you go in with the right claims and you really customize your claims to really go through quickly in Canada, you can get a patent issued within 3 to 4 months. And so that may become quite relevant if you are looking to really be an active participant in what's going on in Canada. If you'd like to switch to the next slide, please. So in the courts, things have also been extended. We have a suspension period in the Federal Court of Appeal. Again, you can see Federal Court's May 29th, Federal Court of Appeal May 15th. I'm expecting potentially some further extensions coming out soon, and this applies to procedural deadlines and whatnot. All hearings scheduled before June 29th have been adjourned. General sittings have been canceled. That being said, some extensions can be made for, amongst other reasons, urgent or exceptional matters. And they are increasingly trying to reschedule hearings and actions through video conference, teleconference. And so there's clearly a movement to try and get things back on track. Of course, in Canada, federal court hears all patent-related cases. So that's important here. Important notice here is, of course, one, you can launch an action. It definitely should if you are suspicious of infringement, or if you want to get something moving in Canada. And these suspension periods don't apply to certain deadlines like limitation periods for launching a patent infringement action. So again, general recommendation, like for most things, if you have an active matter, certainly you should seek specific advice on your particular matter. If you're looking to launch something, then reach out to find out what's available. But generally speaking, tasks are available to take action as necessary. So we can switch to the next slide, please. Okay, so moving on to patented medicines and medical devices. I think there's an interesting opportunity here, obviously, for entities that can come up with a new vaccines or medication or treatment for COVID-19 specifically, or related conditions. In Canada, we have a complex regulatory framework, of course, for dealing with patented medicines. That hasn't changed. I understand that there has been some activity to expedite processing of regulatory applications for example, Class 1 medical devices. So thinking of PPEs and that sort. So something to keep in mind. And I think that's potentially where some of this may come into play when dealing with compulsory licenses. I'll talk on my next slide. In that there are a number of different related industries, of course, that may participate here, and I think it's critical to keep an open eyes on what's going on and what's being pushed. At least in Canada here, the effort to push devices, equipment, testing equipment, whatever can be used to help alleviate the situation and address the situation in Canada has been pushed out. And so it's important for patent owners and innovators to keep an eye out on what's going on, both on their own products, but also on what others are going to push forward. So specifically on new use claims in Canada, those are allowable and have been for a long time. I'd like to point out that it's not only for pharmaceuticals, but any new and inventive use of any known technology can be claimed in Canada, and we use that naturally for pharmaceuticals, where there's a manufacture of a medicament for a treatment of something new that wasn't recognized before, so long as this new use is clearly non-obvious based on the prior art. But it also applies, and we've used that in all technologies really, where old equipment or old testing approaches have been used for a new indication. And so something important to consider when considering products that you already have on hand that you may be changed or modified or targeted for what's going on in the medical space right now. One thing to consider very importantly when seeking to get a claim issued here in Canada for a new use of pharmaceutical, for example, is to beware of not including any kind of language in your claim that relates to the method of medical treatment or anything that would invoke some level of professional skill or judgment. And so often a small tweak in a claim can go a long way to taking that out. So you want to avoid referencing some judgment relating to dosing, for example, or treatment cycles or whatnot. And in the context of getting claims issued quickly, for example, you may want to go in with the right claims right from the start and avoid those pitfalls so that you don't get into this head-to-head argument with the examiner. So start with a clean approach and increase your chances of getting through quickly. And so we'll switch to the next slide. So compulsory license, and moving quickly here. So before 1993, compulsory licenses were quite common in Canada. Things were changed in '93, and some opportunities remain in the Act. For example, abuse of rights under the patents can be used to seek compulsory license. These can be sought after 3 years of grant if the demand in Canada is not being met to an adequate extent, and the grant of a license may be granted if the commissioner think it expedient to do so. So that's one opportunity. Not so commonly invoked, but it does come up here and there. Particularly in this case would be if the demand can't be met in Canada, then that would be one approach. The other type of compulsory license that we can get through in Canada has only happened once in 2008, but it's to get a compulsory license to authorize the manufacture and export eligible drug or medical device to an eligible country. And so we're talking about providing humanitarian aid in other countries. Like I said, it's only happened once in 2008. The process is quite demanding. And so the general sentiment was that it may not be worth the effort to go through it. And you can see at the end that an attempt to negotiate a voluntary license is required before this compulsory license can be issued. But nonetheless, in this scenario here, you can certainly imagine a scenario where there's a demand in certain countries that do not necessarily have the capacity to produce or meet their own demand, and the opportunity possibly to manufacture in Canada for export to those countries, provided that the particular medicament is listed under this section, and for delivery to that country that is also on the list. And I checked yesterday, and there's nothing, of course, there yet. But that's something to think about. I think some countries with a large capacity, with a tie to Canada, could look into this as an opportunity to help other countries. Switch to the next slide, please. And again, before COVID, there's also the ability to get a compulsory license for use of a patent by the government. And this is where, on application by a federal or provincial government, they can apply for authorized use of a patented invention, predominantly to supply the domestic market, but only if the government has made unsuccessful efforts to obtain a license from the patentee. So I understand that there's a bit of a delay in trying to get that license first, the exception being in the case of national emergency, which I think naturally this would apply here. Now, to make that clearer, if we switch to the next slide, as of March 25, 2020, the Patent Act was amended under Bill C-13 to make that clear. And so in this case, the use of patents by the government was extended under application by the Minister of Health. And the commissioner shall, on the application, authorize the government or any person specified in the application to make, construct, use, or sell the patented invention to the extent necessary to respond to the public health emergency. And so I think that's quite timely. Of course, now there are no provisions in there requiring the negotiation of a voluntary license, the idea being that the government needs it. If the Minister of Health requests it, then the commissioner shall give them the license and figure it out after the fact. Can be good, can be risky. Naturally, it is time limited. This provision only, an authorization can only be made before September 30th, 2020. So there's something important here. If you have a patented device or medicine that could be useful and you would like to leverage or take advantage of this new section, that it has to be done before September 30. So there's naturally an impetus to move quickly. The term can be no longer than 1 year from the authorization or when no longer deemed necessary by the minister. And so there's a bit of an open end there, but no more than a year. And of course, there'll be adequate remuneration given the circumstances. And the patentee, really the only thing the patentee could do would be to contest the authorization to the federal court after the fact. I have not heard or seen of any of this taking place yet, but it may very well come into play. And to the last slide, as my time rolls by here, a few recommendations in general. I tried to break this down based on who you might be. If you're an applicant for COVID-19 innovation, there may be a reason to expedite prosecution in Canada, enter national phase early, expedite examination by paying the nominal fees to try to get that first action allowance within 3 months. As you can see, if you can get that patent issued before September 30, 2020, you might get your patent under license through that new provision, which may be beneficial to you, particularly if you're not one to...
Andreas, sorry to interrupt you. If you could please skip to the conclusion. We're running out of time.
Absolutely. Okay, so there we go. So patentees, applicants, you might want to expedite. Patentees, I think it's important that you promote your capability to meet local demand so that they don't invoke compulsory license on you or make yourself known to those who may seek that compulsory license. In the end, I think there's different opportunities here. So to keep that in mind. Okay, thank you very much.
Okay, lovely. Thank you very much, Andre. Thank you, Christian, both for the great presentations. I hope you guys are enjoying this webinar. Please feel free to take notes of whichever point you think are important. However, I would like to remind you that this webinar is being recorded and will be made available through our website, www.daniel-ip.com, or by email, helpline@daniel-ip.com. I also would like to remind everyone that any questions can be conveyed to our team through the chat or Q&A tools of this Zoom tool. So turning now to our next speaker, I would like to invite our colleague Juan Pablo Egaña from Chile, representing the law firm Sargent & Crun. Please, Juan Pablo, the floor is yours.
Thank you, Roberto. If we can go with the first slide. Chile has, I would say, in the continent, a traditional strong patent pharmaceutical protection available. Since 1991, when the current law on industrial property was enacted, Chile recognized protection over pharmaceutical products per se, and all kinds of pharmaceutical inventions now are patentable in our country. The only exception to pharmaceutical patent inventions and the patentability of them is concerning methods of surgical or therapeutic treatment applied to the human body or animal body directly. Concerning the specific kind of patents that Roberto has asked us to look upon, which is second medical use patent or second medical use inventions, these kind of inventions are legally acceptable in Chile. They are recognized in our law. And however, the law or imposes two additional requirements in addition to novelty, inventive step, and industrial applicability for second medical use inventions to be allowed. The first condition is that the application should include experimental evidence demonstrating how the new use effectively works. This rule has been interpreted by the Patent Office, the Chilean Patent Office, INAPI, saying that at least, there are exceptions, in our legislation to patent rights, like the regular ones that are at international level, exhaustion of patent rights, a border exception, and also compulsory licenses. But there, so far, there's no local creativity in the creation of exceptions. With respect to compulsory licenses, it is worth noting that no compulsory license has ever been granted yet in Chile. Nevertheless, back in 2017, 3 years ago, a group of congressmen, two NGOs, and patients asked the Ministry of Health to issue a declaration for a compulsory license because of public health reasons. Public health reasons is one of the legal causes under which you can request a compulsory license in my country. The declaration of the health ministry is a precondition in order to be entitled to request a compulsory license before the authority, which is in this case the Patent Office. In that case, the request to the Ministry of Health was to declare there was the need of obtaining a compulsory license for medicines treating hepatitis C in Chile. And the first questions that arise was, when we're really facing a public health situation? And that was responded basically saying that that would be the case whenever a medicine is not accessible to the population. So that turned immediately to a second question. When is a medicine not available to the population or not accessible to the population? And then, we have basically two lines of answers. The first answer, which was joined by all patentees, was you can only say that a medicine is not accessible when the patentee is not able to meet the demand. But a second line of thought was saying, no, it is possible that a medicine that is made available by the patentee to the market still is not accessible because of price of the medicine. Well, these questions were answered in the affirmative. Because, like in March 2018, the Ministry of Health effectively declared a public health situation in that case. And among the considerations that it included was that the price of the medicine, which in this case was the droxophosphuvir, was prohibitively expensive. And this response, was also mirrored legally in the context of a law, the Pharmacist II law, which was being prosecuted and is still being prosecuted at the Chilean Congress. If we go to the next slide, please. So we have now, with this pre-context that I have told, sort of a changing environment. In Chile, as many of you probably are aware, in October last year, there was a big explosion of social unrest. One of the main causes of this social unrest were basically, the companies or corporations' abuses. And key among them, like a very important case among those abuses that are in the memory of the population, was the collusion of the main drugstore chains that took place in 2008 and was finally condemned in 2012. So access to medicines at affordable prices and in fair conditions was really forming part of the agenda and strengthened a part of the agenda since this political and social unrest of October 2019. And this, was coupled later in March this year or February this year with COVID-19, which put an increased attention on the pharma industry and their ability to just make medicines available to the public. If we go to the next, please. So how rights can be affected, because of these two circumstances. First, concerning patent prosecution and enforcement, I have much to say, that the formulas that we have followed in Chile are pretty much along with the lines of the prior presentators and speakers in this webinar. INAPI, which is the patent office, basically has continued to operate normally, remotely. All the presentations can be made, and they continue to issue resolutions as a normal thing. What they have done is that they have automatically extended the terms falling between March 17 this year and May 15. So all those terms have been extended automatically in half the regular time period. With respect to courts, which are the ones that see infringement, these courts have continued to operate. Normally, you can present a complaint online, so you can prosecute an infringement. However, all personal audiences have been forbidden and are reserved only for very special cases in the criminal and family cases fields. So you can go to court now, you can continue to prosecute an infringement action, but you must know that you will be a little bit slowed in the prosecution of those cases, and everything that needs to be personal, which in many cases are very needed in infringement cases, would not be possible now until new information on our courts. Next, please. And the second front where things are changing a bit, is that in the prosecution of this pharmacist law project, which basically is directed to amend the sanitary code, congressmen, particularly Congress of the opposition and the left-wing side of the spectrum, are very intent now in just making the possibility of compulsory licenses to be easy to grant in my country. So these two suggestions of articles that are mentioned in this slide have been presented. The first of them aiming to eliminate the need of obtaining a declaration by the health minister in order to request a compulsory license when the license is directed to a product that is included in health plans. And the second proposition that is included in this law now is that in the case that the health minister has issued a public health declaration, if the applicant for the compulsory license is a public entity, then that public entity can immediately begin use of the patent and importation and distribution of the product, even before, starting from the declaration of the public health authority, without the need of actually obtaining the compulsory license to begin the use of the patent. The next, please. There's another legal initiatives where we have seen also pending initiatives. There's one initiative to amend the current industrial property law or the patent law, and basically indications or propositions of the same kind are being now discussed. And finally, there was a resolution issued by the Chamber of Deputies on March 17 this year, basically asking the health minister to issue a health declaration indicating that any patent covering any medicine that may serve, medicine or medical dispositive that may serve to prevent, diagnose, or treat COVID should be object of a compulsory license. This, of course, is very aberrant to our own standards, because I mean, like, a compulsory license should be very specific, and basically a blanket license over every single patent, I mean, that may cover something connected with COVID-19, I think is completely out of the law and the standards. However, this resolution has not been attended to by the Ministry of Health so far, so no health declaration has been issued. I finally said nothing we cannot live with, in the hope, I mean, like, that most of these legislative proposals will not come to fruition. And secondly, because I do think that they are very specific for situations that can be framed within, I mean, these very specific circumstances and extreme circumstances that I expect will not be repeated in the near future. With that, I finish my presentation.
Thank you very much, Juan Pablo. It was a great presentation as well, like the other ones. So as the audience can see, we had only 4 speakers, and you could have already a clue on how complex is the environment in Latin America. I also would like to remind everyone that has joined us later on after the beginning, that this webinar is the outcome of a joint effort of Daniel Law in association with 8 other law firms, well recognized and with experienced professionals in several countries. From Argentina, Marval O'Farrill Myral; from Canada, Merizzi, Ransbottom and Forster; from Chile, Sargent and Cram; from Colombia, Olarte More; from Ecuador, Coral Rosales; from Mexico, Olivares; from United States, Nob Martins; and from Uruguay, Fernandez Seco. With that said, I would like to turn to our next speaker from Colombia, Alexander Agudelo.
Thank you, and good morning to everyone. Thank you to Roberto and to Daniel IP for the invitation to share some information about Colombia in the following few minutes. So let's begin. Next slide, please. Okay, so to begin, I would like to share some information regarding the operation of institutions here in Colombia at the administrative level and also at the judicial level. The Patent Office is working almost normally. Back in March, it closed for a few days, but they were able to resume activities very soon. So they've been working normally through electronic means, and they can receive everything virtually through their online database. So you can file new applications, you can submit responses to office actions, and everything is working normally at the Patent Office. And at the judicial branch for infringement procedures, for example, we have in Colombia 2 main venues. The first and preferred venue is the Patent Office itself, the judicial division of the Patent Office, and it is also working normally. We can file infringement complaints, we can pursue preliminary injunctions also through electronic means, everything virtually, and it is working properly. The other venue, the traditional one, involving civil circuit judge, it is closed. All terms for that traditional venue are suspended, and we hope that everything will be resumed after 30 May. We in Colombia, we have a bifurcated system, so validity issues are pursued before the Council of State, that is our Supreme Court for administrative matter, and that court is also closed. All terms are suspended, and we also hope that they will resume activities after 30 May. So in summary, Patent Office is working normally for administrative issues and prosecution, and also the Judicial Division for infringement action. But the traditional venue involving judges and validity issues at the Council of State are closed and everything is suspended. Next slide, please. Hello. Thank you. So for the second topic regarding compulsory licenses in Colombia, first I want to give you a brief overview. Compulsory licenses in Colombia are governed by the Andean Law, Decision 486, and this law provides 4 grounds for requesting an issue in compulsory licenses. The first one is when the patent is not properly worked. The second ground involves public interest, emergency, and national security. The third ground is the abuse of dominant position by the patent holder. And the last reason for a compulsory license is when a cross license is needed in order to work a further patent. For pharma cases, which is of interest in this webinar, the second ground is the one that is involved, and in particular the public interest. The requesting an issue in compulsory licenses in Colombia is completely regulated, and it involves essentially 2 steps. The first step relates to the issuance of a declaration of public interest, and it is performed by the Ministry of Health. After the petition of a compulsory license is filed, the Ministry of Health will take over the case, will analyze the case, and will issue or not a declaration of public interest. If the declaration of public interest is issued, then the second step involves the patent office, wherein essentially a bidding process is opened in order to receive offers from third parties interested in having the license. And it is the patent office who actually issues finally the compulsory license, and will also always provide a reasonable compensation to the patent owner. This is a must. The patent owner always will receive a reasonable compensation. Next slide, please. Thank you. Here, surrounding, no, that one, yes, thank you. Surrounding the current situation of COVID-19, what happened recently is that in March, the president issued a special decree, Decree 476. And that decree provides the Ministry of Health with special powers to issue declaration of public interest, particularly related to drugs and medical devices involving COVID-19. So in theory, that decree 476, would facilitate obtaining an issue in compulsory licenses. However, that decree is silent regarding the second step of the proceeding to issue a compulsory license. It is nothing said about the bidding process that the patent office should perform. And also, one cannot forget that in order to issue a compulsory license, the Ministry of Health should conform a specialized committee to analyze the case technically and to issue the declaration of public interest. And the second important point is that the patents that would be object of the compulsory license should be specifically identified. So those 2 issues would difficult a little bit the request an issue of compulsory license, despite the presidential decree that was issued. So bottom line, that decree alone would not be enough for obtaining compulsory licenses in Colombia. Next slide, please. Okay, and this is a summary of the actual cases we have had in Colombia regarding compulsory licenses. The first one was Caletra. This is an antiviral drug for treatment of HIV that happened back in 2006. And in that case, and in all cases we have had in Colombia, petitioners are usually non-governmental organizations, also patient organizations that make the request of the compulsory license before the Ministry of Health. For that first case, Calitra, the declaration of public interest was not issued. That was in fact rejected. And the grounds for rejecting the compulsory license that the ministry used was that no access problems were real, were happening for patients in order to have the drug. So in that case, no compulsory license was issued. The second case happened a couple of years ago, and it was related to the drug Glivec. For that case, the declaration of public interest was indeed issued by the Ministry of Health, but curiously, it was that declaration of public interest stated specifically that it was not for purposes of a compulsory license, but rather for purposes of price regulation. So bottom line, the request and the procedures for compulsory licenses in Colombia have been used by the government in order to force and negotiate prices with the patent holders. And the third case that was initiated a couple of years ago involves drugs for hepatitis C, but the same non-governmental organization that requested the investigation in all those cases, failed to list specific patents that would be subject of hepatitis C compulsory licenses. So the investigation started, the process is open, and in theory it is ongoing, but it has been suspended at least for 2 years because the petitioners have not been able to list the specific patents that would be subject of compulsory license. So in summary, the message here is that the procedures to obtain compulsory licenses in Colombia is very specific, is very, you have to follow all the steps and you have to involve all national entities, the Ministry of Health and the Patent Office, and it is not an easy procedure. So it is not easy to request and obtain compulsory licenses. Although in theory it would be facilitated, in practice it could take time. And next slide, please. Finally, I want to highlight that Colombia is part of the Andean community with Ecuador, Peru, and Bolivia. So we have the same IP law. We share the same IP law, that is Decision 486. But no regional patent exists for the Andean community. Each country has its own patent office, and in fact, there are differences in practice, in the interpretation of law, and also in processing speed. Despite that, we have the same law and we share the same legislation. That being said, that law particularly specifies in Article 22 that no second use patents are allowable in the Andean community. So statutorily, second use patents are prohibited in the Andean region. And okay, that's all the information I wanted to share today. I would be happy to answer any questions you have. Thank you.
Thank you very much, Alexander, for the great insight about Colombia. As the audience can see, or was made clear so far, is that compulsory license is really an exception to the rule of granting an exclusive privilege or monopoly, if you will, for a certain period of time. And so it should be treated accordingly, really, as an exception. And that meaning that conditions for obtaining a compulsory license should not be simple stuff, but obey two specific circumstances. Okay, now we'll turn to our First Lady that will be presenting today. I would like to invite Maria Cecilia Romolero from Ecuador, representing Coral Rosales. Maria Cecilia, can you please share your insights about Ecuador, please?
Sure, thank you so much. And thank you everybody for listening. Well, Ecuador always makes the news. Please, first slide. We are in mandatory quarantine since March 16. All terms are suspended. The IP office is working remotely and accepting online applications. However, infringement actions could be filed, but will not be heard until the quarantine ends. This is because inspections need to be conducted. Regarding civil actions could be filed. However, they will not be heard until the quarantine ends. The Supreme Court and the Second Instance Court are working regularly since last Monday. Regarding criminal actions, there are no criminal actions for patents, so it's necessary to think out of the box to be able to criminalize a patent infringement, as criminal actions are the best actions to pursue. But police currently conducting raids regarding COVID-related infringements. Border measures in Ecuador are almost non-existent in practice, and in any case, they do not apply to patents. Next slide, please. Next. Regarding second, no, prior one, please. Regarding second and novel uses, they are not patentable, as my colleague from Colombia mentioned. This is following a judgment from the Andean Court of Justice issued in 2000. Also, Swiss-type claims are not allowed. Next, please. We have a supranational law, as Colombia already mentioned. Ecuador is a member of the Andean community and applies Decision 486 as a supranational law. This supranational law sets the rules for compulsory licenses. Next, please. What makes us different from Colombia and Peru is that we have a local law that has had a lot of criticism for many reasons. The local law includes additional rules for compulsory licenses, which will be contrary to the communitarian law and therefore non-applicable. The main problems this law has, or the main contradictions, would be that the use is required to be performed in Ecuador versus the communitarian law that requires use in any of the Andean countries. Another aspect is that compulsory licenses will be granted in case of antitrust practices, including abuse in the dominant position. Another thing is that compulsory licenses will be provided for internal markets and for export without any regulation or without any limit. Next, please. Next. You will recall the prior. You will recall Colombia explained the prior one, please. The prior one, please. The prior one. Prior one. The prior one. There. Now the next one. We're having problems with the slides. I'm so sorry. I don't know if you are not listening. Okay. You will recall that public interest is one of the main requirements for granting compulsory licenses. Well, Ecuador declared of public interest all pharmaceuticals to treat sicknesses without any time limit in 2009. Next. Next. Ecuador also has rulings for issuing compulsory licenses. These rulings are quite general and are contradictory to the Andean law, and also they do not match the TRIPS requirements. TRIPS required an analysis on a case-by-case basis, and these rulings are general, providing for compulsory licenses for all matters. Next. Let's look at the history in Ecuador. There were 41 applied for compulsory licenses. From those 41 cases, 10 were granted. All of them are now lapsed. There were 31 rejected actions, either abandoned, rejected, or withdrawn. Currently, there are not pending compulsory licenses applications. Next. Next. We were one of the first countries getting the virus in Latin America. You probably heard we made the news because of the Guayaquil problem and all the death toll in Guayaquil. So the Congress requested the executive branch to issue a compulsory license for all patents related to COVID. This request was done without any technical study or any technical background. It was just an, I would say, like a idea that someone had and issued this request in the Congress. Next. The IP office answered this request on behalf of the executive branch, basically asking the Congress to ask them for information before issuing any of this request. They also explained the criteria for granting compulsory licenses, and they stated that compulsory licenses could not be issued in Ecuador at this time for COVID, as there are no patents related to COVID. They also issued general information regarding compulsory data. A good question for Ecuador is why there are no patents regarding COVID. I think it's a long story for another rainy day. Thank you so much.
Thank you very much, Maria Cecilia. Really, the situation in Ecuador, as in every country, I would say, is very sad due to this pandemic. And we have our prayers with all the families that are suffering with these very sad conditions, and hoping that these days they end as soon as possible. Moving on a little bit north. I would like to invite our dear colleague Alejandro Luna from Mexico, representing Olivares, to share the insights about these topics we have selected for today. So Alejandro, please feel free to start whenever you're ready.
Thanks. Thank you, Roberto. Do you hear me?
Yes, very well.
Perfect. Thank you, Roberto and Daniel Law for this opportunity to comment about the topic of compulsory licenses, which is a very, very interesting topic. I would say in theory and in the academia, but I believe that no one really wants to have it in place, because in Mexico, the implementation of compulsory licensing will require serious threat to the national security, and we are going on that further. Next one, please. Next slide. Thank you. In Mexico, according to our constitution, the highest health authority is the Health Council, the Federal Health Council. However, our legal system provides some faculties and powers for the regulation of certain issues in connection to health to the state and local level. I will refer refer mainly to measures taken by the federal bench. One of the first measures adopted to prevent, to stop the outbreak of COVID-19 virus was the suspension of activities for, I would say, majority, if not the total, of the federal entities and authorities. The first decree from March 18 to May 19. However, this period was extended until June. Generally, it was extended until June the 1st. Today, we had an announcement very early in the morning that some of the measures, they are going to be extended with the exception of some of the essential sectors. Obviously, these suspensions of activities included our IP or intellectual property authorities, our regulatory agencies. In short, I will say that from now, officially, the Mexican Patent and Trademark Office suspended activities and no terms they are going to run from March 24 to May 31. And we don't know if that period is going to be extended due to the measures that were announced today. We need to expect. However, the good news is that we are able to file online new applications for trademarks and patents. That is available, and we are able to file these new applications for trademark and patents. And 2 days ago, on May 11, the Mexican Patent Office announced a broadened scope of the catalog of motions that can be filed in this electronic window. It is more related to trademark prosecution. Actually, today, at this moment, there is a tutorial before the Patent and Trademark Office in order to explain how this new tool of the electronic window is going to work for this type of proceedings. Of course, that the suspension does not apply to a proceeding which is necessary to face or to mitigate the consequences of the pandemic. And that rule applies for most of the suspension decrees of all authorities. And in connection with the Mexican Patent Office and in connection to patents and compulsory licenses, I would say that it is working because within this period of suspension of activities, the Patent and Trademark Office was open for us to file a motion that it was requested by ABI in order to devote all the patents and applications in Mexico related with the product Caletra, Lopinavir, which it has been shown to have some therapy benefits to treat COVID-19. And the Patent Office was open for us only to file this motion to devote to the public interest all the patents to Caletra. So that is working. Now, in connection also with the Mexican Patent Office and the subject of new uses. New uses are granted and recognized as a patentable subject matter by INPI under the current practice. There is nothing in the statutory law recognizing this patentability subject matter. However, it is a common practice and it is recognized. It has been enforced successfully. And in response to this subject, use claims are accepted under the current practice in Mexico. Actually, we suggest that the claim will follow the purpose limit product patent claim format, because it would be better for purpose of the patent linkage in Mexico, which is very helpful in order to avoid the infringement of pharmaceutical patents. Next one, please. Next slide. Regarding enforcement of IP rights, appeal proceedings, and criminal administrative actions, legal actions, it is important to mention that the Mexican Patent Office, INPI, has the original jurisdiction to enforce patents, trademarks, and designs in Mexico, and also to review the validity of patents. And those proceedings, the suspension has not been formally lifted by INPI. So currently, it is not possible to enforce in the administrative arena patents and trademarks. The only exception for contentious proceedings before INPI is that it will be related to, in some extent, to COVID-19 crisis, or to lift or release preliminary injunctions, but not to enforce patents on trademarks. So that's why we still, as an association and as a law firm, Olivares, we are insisting before the Mexican Patent Office to have an emergency window to file this type of motions and actions and proceedings. We are waiting for that. And we don't know if with this electronic window announced 2 days ago, maybe we can have some access to file some motions for contentious proceedings and to enforce patents and trademarks through the administrative proceedings established before INPI. However, the criminal actions are still available because that are prosecuted before the state criminal prosecutors and federal prosecutors. So that is possible, but it is limited to anti-counterfeiting actions, to defeat falsifications of products and trademarks. But also there are some actions for pharmaceuticals when there is some health risk. So those are available, still available. Okay? Those are not suspended. Also, but it is important to highlight that they have some limit in the personnel and the officers available to prosecute those criminal actions. Next one, please. Next slide. Next slide related with compulsory licenses, please.
We're having a small technical issue, Alejandro. Okay, now we got it.
Now, thanks.
Okay.
Thanks. Now to the topic of compulsory license. I will highlight first that there are two types of compulsory license established in our IP law. The first one is for lack of exploitation. When the invention is not work in Mexico, after 3 years of the granting of the patent, or 4 years after the application, and the invention is not used in the Mexican territory, and there is no cause of would be an exception for using or exploiting the patent in Mexico. There is one single precedent. I mentioned this because some of the rules, some very few rules of compulsory license lack exploitation apply also to compulsory license of emergency, on causes of emergency. There is one single precedent in May 62, and it's curious, but in technology, it was for hangers of clothing in an automatic laundry. It's a single and isolated for compulsory license for lack of in Mexico. Next one. But obviously, the one that deserves attention in this seminary the compulsory licenses by causes of emergency. And I will divide it in two: the proceeding to get the compulsory licenses in place, and the causes of compulsory licenses, which are key and essential in our legal system. The proceeding for compulsory licenses, what the law says is that it should necessary a declaration of emergency or national security, including the declaratory of a disease of priority attention by the General Health Council. That already happened in Mexico. In March 24, as far as I recall, the General Council, the Health General Council, declared COVID-19 as a disease of priority attention. And also there is a decree by the Mexican president established the pandemic of COVID-19 as a cause of emergency. Okay, so that step has already taken place in Mexico. Then it's necessary that the cultural disease of priority attention can be requested by a specialized institution by the General Health Council. The Mexican office will determine what is exploited through compulsory license. That has not been taken place yet in Mexico.
Yeah, Alejandro, if you could please start skipping to the conclusion.
Yes. Okay, next one, please.
Thank you.
Because the causes and conditions are relevant. The causes for compulsory license in Mexico is that there should be a shortening of the product. There should be an overprice of the product, or an undue control of the product. That should be causes for compulsory licenses in Mexico. We have this precedent in 2009 regarding the influenza H1N1, and no compulsory licenses were necessary at that point in time. We really expect that this will not occur at this time, because if an accepted treatment does become available for COVID-19 and it is protected by a patent, we hope that similar to what happened in 2009, the treatment will not be short supply for various reasons that happened in 2009, such as compassionate use licenses, pandemic prices, public and private cooperation and negotiations, free licenses, and the release of rights as happening with Calitra. Because, and this desire is not only because our devote to exclusive rights from patents, but also these conditions for compulsory license are not met. That would mean that as a country or as a humankind, we already defeated this virus or this outbreak of COVID-19 as an invisible enemy. So in conclusion, I would say that the conditions and causes to grant compulsory license in Mexico are very strict and are very limited, and they match or they fulfill all the prongs and requirements international treaties such as TRIPS and NAFTA. And some proceedings and some rights of the title holder, such as the right to be heard and reasonable payment of wrongs, should be fulfilled in order to grant this compulsory license. But especially these three main causes: shortage, overprice, and undue control of the product. If those causes are not met, the compulsory license in Mexico cannot be granted. And with this, I finish my presentation and open for your questions. And thank you for the time, Roberto.
Thank you very much, Alejandro. Just before I turn to Dan, a quick information. As I said, the webinar will be available through our website or by under request by email. That's about the webinar. However, the slides that you are seeing during the presentation of the speakers, they will be sent automatically to everyone that has subscribed for the event. So I would like to turn to Dan Altman from the United States representing Noble Martin. So Dan, can you please move on when you're ready to do that?
Certainly, thank you. I do have to apologize in advance if you hear some extraneous noise in the background. My wife and I adopted a new puppy this weekend, and she works on her own schedule. And so if you hear sad dog sounds, I apologize. So if I could see the first slide, please. So I'll begin with the state of the USPTO and the courts in the US. The USPTO is open, and from the outside, it would be very difficult to tell that anything unusual was happening at the patent office. And that's because a large majority of the patent examiners and certain other staff members at the PTO already work from home just in normal times. And so the functioning of the patent office has barely changed. And the facilities at the patent office in Washington, DC, as well as the regional patent offices, they're all open to the USPTO staff. The public is not allowed to enter, but the staff are functioning as normal. And there were three special provisions that relate to the COVID situation, but they're not particularly important. One relates to the fees that are available in the event an application goes abandoned. If the application was abandoned as a result of difficulties from the pandemic, those fees can be waived. The other is that a 30-day extension can be obtained, but the conditions are somewhat onerous, and so it's not particularly useful. The third type of special provision is that if an invention relates to COVID-19, then special status can be granted to that application, and a patent can be granted in as little as 6 months. So turning now to the courts, the US is a federal system, and so the jurisdiction is divided between federal courts and state courts. Each one has their own role. Intellectual property is primarily done through federal courts, but the state courts have some role with regard to some of the ancillary types of IP, such as trade secrets and rights of publicity. And the federal courts are a mishmash of different statuses right now. And that's because each district has its own rules, which are set in accordance with the state in which they're located. And so some district courts are functioning quite normally, quite close to normally. No courts anywhere are impaneling juries. And one of the peculiarities about the US law system is that we have juries for civil lawsuits, and that includes patent cases. So there aren't any trials, but most lawsuits are able to continue, at least in some form, through virtual hearings. And those are conducted with different rules depending on which district they're in. So the courts are proceeding. The state courts, each state is completely different. And if you have a matter in state court, if you have a choice to bring it in federal court, you're probably better off to take it up to the federal level. So if we can see the next slide. So with the courts in this somewhat precarious situation, some working well, some not working well, What does that mean about enforcing patents or responding to allegations of enforcement? Well, really all strategies remain available because the courts are at least open to some extent. Infringement suits can still be brought. All courts are accepting lawsuits. And the type of extraordinary relief that is sometimes required, that is the type of thing that can still be pursued. So temporary restraining orders and preliminary injunctions, this is interim relief to preserve the status quo. Most courts will accept an action for one of these types of relief because they are so extraordinary and are based on the idea that extraordinary relief is required. But delays should be expected because of the differences in the way that the courts are operating. And delay generally aids the accused infringer. And so if you are the patentee trying to enforce rights, then you may need to require more aggressive action than you might have otherwise, because the accused infringer may have some room to maneuver just based on the delay. So let's see the next slide. So the main topic today is compulsory licenses. Compulsory licenses as such are not available in the US. There are no provisions for them, and COVID-19 hasn't changed that. However, there are two compulsory license-like provisions in the US law. And one is this section 498A, that says that the US government always has the right to infringe any patent. So they don't need to go through any proceeding, they just can go ahead and infringe. And they can extend this right to their contractors and the subcontractors of those contractors. So they are absolutely immune to infringement. However, they do have to provide some compensation to the patent owner. And if there's a dispute, it's over the amount of the compensation. So it's quite likely if there is a patent on a COVID-19 related invention that the government can intervene and begin manufacturing, doing whatever it thinks it needs to, and to provide licenses, an effective license to its contractors and subcontractors, so that COVID-19 related inventions can proceed without any interference by the patent owner. The other compulsory license-like provision are the so-called march-in rights. And this comes from a 1980 statute that said that when the government funds an invention, the owner of the invention will be the person who did the work, not the government. But as part of the deal under this statute, the government can march in to require a license to a third party. So since 1980, there have been 14 requests made by third parties where they've asked and said, this is an extraordinary circumstance. We believe that we should be granted the right to have a license under these march-in rights, but none have been accepted. I participated in the very first one, which was about 20 years ago already, maybe 15. And in that case, the grounds were really quite compelling. And the federal agency that was involved, it's the National Institutes of Health. They were the organization that funded the research. They impaneled a group of scientists and administrators to review the request, and ultimately decided that the conditions for a grant of these types of march-in rights had not been satisfied. And the next 13 requests were all with the NIH again, and they reached the same conclusion. So I don't know whether COVID-19 would change this, that it would make it so compelling that the government would actually march in, but so far they never have. So the next slide, please. Second medical uses in the US are very robustly protected. The US is one of 2 countries that I am aware of where a medical method claim can be obtained. So a method of medical treatment can be obtained. There's no limitation on that. And it's not just new uses for old substances, it's new uses for old devices. So even a surgical procedure. Now, the reason that most countries do not permit medical method claims is because of this idea that it's important that physicians and healthcare entities not be prevented from using their best medical judgment in order to help their patients. So the US deals with that in a different way. They permit the medical method claims, but the healthcare entities cannot be sued for infringement. So they can carry out whatever they deem to be medically necessary without fear of suit. But it's still technically called infringement. And the reason why that's important is that under the US law, the types of indirect infringement, induced infringement, or comparative infringement, these types of infringement require that there be an actual infringer. So the healthcare entities or the doctors are the actual infringers, but they can't be sued. But who can you sue? You can sue the pharmaceutical company that is promoting the use of the old substance for new use. Or they can sue the medical device manufacturers who's promoting the device to be used for the new use. And so this is the type of action that's likely to be brought in the US if there is a new use in terms of COVID-19 for an old drug or an old device. So this statute will very likely come into play during COVID-19 where there is a second medical use. So I think that's the end of my slides. So we can move on to the last but not least country.
Thanks very much, Dan. With no further delay, I would like to turn to Agustina from Uruguay, representing Fernando Seco. Agustina, please. Agustina, I think you're muted.
Hello, sorry. Thank
Okay,
you,
no
Roberto.
problem.
Thank you, Roberto, for inviting us to join. The team at Daniel has been fantastic in organizing, and I know that we are all starving, so I'll try to make it quick and cover the points that we will be discussing today. So, Anna, if you can move to the first slide, I can start with the presentation. Well, Uruguay, I would like to begin by saying that Uruguay has had COVID-19 quite under control. That's something for now, of course. This is a changing scenario, but we have not had mandatory lockdown. Unfortunately, this has allowed us to keep up and running. And in the case of the patent office, we've had online filing and online notifications way before COVID. So no terms were suspended and operations have been normal. We have had a few cases in cases where legalizations or apostille documents have been impossible to get due to the crisis in other countries, or there are some very few cases of hearings at the office that have been rescheduled. Thankfully, our procedure code allows for force majeure circumstances to be claimed, and in conversations with the Trademark and Patent Office, they have said that they will, of course, consider these scenarios and allow a special term on a case-by-case basis to those that have been affected by special circumstances, which I guess is almost everyone. But despite this, we expect some delays as the examiners were not used to working remotely, and adapting the system to work remotely, especially examiners with very large files, like in the cases of patents, is complex. So we expect some delays, but all of the office actions and usual filings at the office have been working normally. Regarding the judicial system, we have two forums. First, the TCA, which is the Administrative Justice, which deals with the revision of all administrative acts. Well, at the beginning of this crisis, both the TCA and the judicial branch, which is the Supreme Court, issued decisions claiming, okay, a state of emergency and suspending terms for certain periods. This was postponed sometimes as the crisis was unfolding. But fortunately, we are starting to see the light at the end of the tunnel. These decisions by both the TCA and the Supreme Court created some debate between the academy as to the effects, same as Andre commented, whether those extensions affected, for example, statute of limitations, expiration of rights, or applied in other cases. So on the 30th of April, the Parliament passed Law 19879, which sort of clarified that these terms were suspended, same as in the court recess of summer and other regular court recesses. So that was cleared out, and now the TCA has started receiving documents as of the 11th of March. They did this like smooth opening, receiving documents from the 11th of March, but terms will start running on the 1st of June. So to avoid crowds at the door of the TCA, which wouldn't help the crisis. And in the case of the Supreme Court also deals with urgent and exceptional matters. So they've been working on those matters when there is, when the delay it is a risk for the right involved. So we have seen during the COVID crisis seizures of counterfeited goods by customs, not patent, but yes, trademarks. So I do believe that if the case had presented, they would have acted similarly, because it's basically run by the same offices and under similar provisions of the criminal code. So urgent matters have been running, although judicial actions, both criminal and civil, were suspended due to the crisis and are resuming on the 15th, this Friday. Similarly, like the TCA did, the Supreme Court had this smooth opening where you can file from the 11th, this Monday to Friday, of all the terms to avoid crowds. Now moving to the next slide on compulsory licenses. Well, I have to begin by saying that Uruguay has several ways in which compulsory licenses can be established. Non-use is one, or the fact that the owner of the patent denies a license under reasonable commercial conditions. But due to the time frames in those other two scenarios, they wouldn't be very applicable to this case. So I will focus on compulsory licenses in case of emergency, which I think is the applicable, the reasonable standard to use. I like to say that Uruguay has a long-standing tradition of abiding international treaties. So I would say that pretty much all of our patent law is in the line with a very balanced approach that is, I believe, recognized by international treaties in the matter. So the requisites for a compulsory license are the existence of a health emergency or special situations that could affect the general interest, economic or social development. I think we can all agree that this is a health emergency. And it's been declared by the executive at the beginning of the crisis on March 13. Then another scenario is insufficient supply to meet the needs of the internal market. These two requisites are not, they don't have to be together. It can be either of them, but I think the case scenario is that we will probably face both at the same time. And our law establishes that the scope and duration of the license has to be adapted to the end, which I think also shows this reasonable balance between the needs and the sacrifices that are allowed under the trademark law. The law foresees a 30-day notice to the owner of the patent or the application. And the process must guarantee the participation in equal conditions to all interested parties in the exploitation. This would mean all parties interested in obtaining a compulsory license. And also foresees conciliation and arbitration, which will, I think, play a very important role in determining the reasonable compensation that has to be granted to the owner of the patent. We have not had any cases in which this law has been applied, and regulation, to be honest, is very discreet. We don't have large regulation on this regard. I think it's something that we all share, because it's not something that happens on a day-to-day basis. So Anna, if you can move to the next slide. I would like just to comment very briefly some problems I can foresee with the drafting of as it is, or the wording of the law as it is. First, I have to say that Section 55 refers to patent title holders. They don't refer to applicants. I think this doesn't necessarily mean that it's not the spirit of the law, and I don't think it will be regarded as something that it's not allowed. For example, in consensual licenses, we see that the law clearly establishes that a patent license can be registered for a patent application, and it does not require it to be granted. And another problem that may rise is Section 99 of the patent law. This section has suffered changes, and I say suffered because the changes were very bad, were very poorly drafted. And the aim of those changes was to hinder the right of the patent owner to reclaim damages from publication up to the granting date of the patent. In the process, we have a large backlog, but the wording as it ended up being passed in the change is not clear. So I would say that we haven't had any court cases after the change, and it's very arguable whether the change was effective as to not allow the owner of a right, a patent, to reclaim damages for that period. So those are issues that I think will be part of the discussion if this becomes a reality and all the players start debating. So just to give you a bit of information on that. And now moving to second uses. Same as you suggested, Roberto, in Uruguay, second uses are not foreseen nor forbidden by the law. So typically they are not admitted by the patent office. I would say that it's very, very rare. I've heard of some cases where they have, but again, it's very arguable whether this was just a second use or if there were other elements that were taken into account to grant protection over those inventions. However, there's a very important hint in Section 55 of compulsory licenses, which refers to compulsory licenses for other uses. So I think in the event that the solution to the crisis comes from another use of an existing patent, the actual wording of Section 55 gives the patent owner a very strong position, because especially Section 55 allows the executive to grant compulsory licenses over other uses. So this is an interesting case where a very, very limited exception of the law would be an argument in favor of second medical uses, which are currently not being recognized as a general rule by the practice of the trademark office. So with that, I conclude my presentation. I try to keep it short so we can all go and get some lunch. And I would like to thank you again to you, Roberto, especially, and to all of the panelists. You've been fantastic. And of course, to everyone that has been listening, it's been a pleasure sharing with you today this information.
Thank you very much, Agustino, for the presentation, and thanks for the effort in keeping your time straight. We still have a lot of participants. Our audience is almost 90 people still online. So considering that number of people watching us, and as well as the questions that are coming, I assume there's still interest in proceeding a few more minutes, even if we have already reached our limit. So if anyone, of course, for any reason needs to disconnect because there are other appointments or things to do, we will fully understand. So if any of you or all of you preferably can stay with us, we will open now the first questions that we have received by our chat, which is very well animated. So I will now turn to Ana Cavalcanti. Can you hear me, Ana? You're muted to respond. Can you hear me, Ana?
Yes, I can hear you clearly. Can
Okay.
everybody hear me?
Okay. Lovely. So can you please start, maybe we'll do 2 or 3 questions for the panelists here. Can you please start with the first one?
Of course. Our first question is from Suelen Camargo to all the panelists. Patent law is territorial, so no surprise that the scheme of compulsory licenses vary from country to country. What would be the best approach for a pharma company that is now or planning to develop new drugs in the context of COVID? Due to global interest in the cure already announced by the World Health Organization, and most of the European Union countries, and could any one of the countries in the presentation seize a patent issued by another country that does not have a compulsory licenses scheme, or these compulsory licenses would, as the general patent law, only be applicable within the jurisdictional territory? I was just wondering how flexible global and international laws would play in a situation of global emergency, as we now see it with the pandemic.
Well, it's a quite long question. I'll try to summarize. And we're in 9 panelists, so if everybody wants to answer, just raise the hand. But I'll try to summarize. I think that the question says respect to the possibility of a global initiative influencing local legislations in order to foster or facilitate the issuance of compulsory licenses. So anyone would like to answer, representing some other panelists?
Can I speak based on my US-centered bias?
Please, go ahead.
So given the differences in the scheme in every country, the only unifying part of this would be the patent holder itself. And so if you negotiate with a patent holder and obtain the rights, you can negotiate the rights globally. And that's one way to negotiate in one place without having to negotiate with governments in every country around the world. And I think, as I said, my bias reflects the US approach, which is that compulsory licenses are not really available. But there are certain advantages to it, because in an emergency, when you need to proceed in every country, it could be unduly complicated to negotiate with every country around the world.
Thank you, Dan. I think your answer in some way responds what many other panelists would say. Because of the time constraints, I would suggest, Anna, that we convey this question in writing to the remaining panelists, and they would directly provide an answer by email or phone to Suelen. Suelen, I will apologize for not being able to go one by one in this panel, but we're running out of time, and I would like to open the opportunity for others to, make the questions, but you will have your question answered anyway, however, in writing or in further contact with your other panelists. So Anna, can you please move to the next question?
I have a question from Flavia Trigueiro. It's for André Merizzi from Canada. Considering the COVID-19 pandemic, and new Canadian legislation, will the Government of Canada first verify if the patentee has the capacity to meet local demand? Will the government give preference to a voluntary license before issuing a compulsory license?
Good question, thank you. So, you know, if we look at the new provision in Canada, they specifically include, you know, that they will give the license to the extent necessary to respond to the public health emergency described in the application. And so in that context, and I think it's prudent to consider that if the patentee can meet local demand in Canada, then the government won't feel the need to step in and issue the compulsory license. So I think that term here, to the extent necessary, is what we need to lean on to think about that. Again, I think in most respects, if a voluntary license can come into play without the government stepping in, then I would presume that they would prefer that over stepping in. I think the weight of this bill, or the real intent of this bill, was that if there's an issue and we can't come to a reasonable agreement very quickly, then there's provision there where we can bypass all that effort, and the government can just step in right away and say, let's give this license, let's meet the demand because that's an emergency, and we can resolve these issues after the fact. And that's the main difference that this new section 19.4 brings in, is this overstepping the need for previously negotiating. It'll be interesting to play out, and I can see that coming up in the next few months.
Terrific. Thanks very much, Andrea. Any other question, Anna?
Yeah, we still have quite a lot of questions coming up. This one is from Hannah Gozain to Roberto Ribeiro. Price discrimination is a worldwide practice of pharma companies. Basically, involves applying low prices for low-income or developing countries. If lower prices were applicable to blockbuster drugs, possibly this could avoid compulsory requests. If Merck had practiced a lower price for ephedrins, as in Thailand, the Ministry of Health might have come to terms.
Thank you to my esteemed colleague, Rana Gozain. Well, it's a tough question, Rana, because I'm not fully aware on how the negotiations between government and Merck proceeded, and I'm not sure I could be clear about how the price really came into play and had a major role in determining the decree that resulted in the compulsory license of ephedrins back in 2007. But certainly, generally speaking, in a broad scope, a low price of a medication will be one good reason for the government not to fight seeking for a compulsory license, because the difficulties involved in that negotiation would not justify if the price was low. And it's important to remind at this point in my speech that in Brazil, prices are not unilaterally set by the pharmaceutical company, but they're set under an administrative process that has been put into place by the government, by the way. And there are a full set of criteria to be met, questions to be responded, conditions to be observed, etc., to come up with a final price. So if a medication in Brazil has a price that is considered high, so to speak, by the government, there is some influence, I would say, by the criteria that the government themselves have set to put the price. So in other words, there wouldn't be much room to complain, because the price, I assume, was set under a fair basis based on the legal process set by the government. So, Brad, I'm sorry to not being able to respond specifically for ephedrins. I never worked for Merck or had contact with them, but I think that price might have been one of the reasons. One final question, Anna, and then I think we'll should free all the panelists to take care of other issues. So if there one last question, Anna, I would like to ask you
Sure.
to pose it, please. Thank you.
I have a question from Catherine Gonzalez to Christian Bettel. We all have seen in the news that a group of Argentinian scientists are working on several promising trials looking for a COVID-19 vaccine or treatment. However, as mentioned, Argentina has no experience in compulsory licenses, since none has ever been granted and the procedure is not clear. How are the IP office and national executive dealing with that? And what to expect if the trials are successful?
Well, thank you for the question. It's a very interesting one, and we'll show you the way the controversies we do have. You know, even though we do have, many good researchers in biotech and biology fields. I mean, we have a long tradition in that regard. Our patent laws and criteria are contradictory in that regard. In fact, in 2006, a law was passed, which, it's a law to promote modern biotechnology, and basically it gives tax benefits to companies doing biotech developments, and that's and the beneficiaries must make a compromise to patent or any developments they have made. And it's interesting because that law states that if the invention is not patentable in Argentina, then inventors should seek protection elsewhere. In the end, that means for biotech inventions, we usually have very poor coverage for that particular development. Vaccines and treatments related to COVID. I wouldn't be very optimistic regarding the kind of protection they could get in Argentina. Basically, treatments are not patentable, and it's really hard to get protection for a composition. Usually, vaccines are compositions, typically comprising natural proteins, which are not patentable per se, according to the guidelines of the patent office. And on the other hand, as I mentioned in my presentation, I guess, and again, this is a personal opinion, I don't imagine the patent office in a rush to grant patents for COVID-related inventions. So in practice, what will happen is that our scientists will probably develop these treatments, these vaccines. They will not be able to get patent protection, and therefore no compulsory license would be necessary. Unfortunately, that's what I would expect.
Great, Christian, thanks very much. One more time, I'd like to remind you all that the slides will be automatically sent to your emails for you that have subscribed for this event. My appreciation and repeated thanks for having been with us this time. If you are interested in having a copy of the recording of this seminar, it can be requested by two different channels via our website, www.daniel-ip.com, and helpline at daniel-ip.com. Both addresses are appearing on this last slide. I will now turn to the panelists and would like to thank very, very much for the collaboration, for the high-level material that you guys all have prepared and have presented very clearly and brilliantly. And finally, to the audience, to say my appreciation and say that we are all available for any consultations or further discussions that you may be interested in. And also would like to thank our backup team, Ana Leo, Ana Cavalcante, Marcelo Putz, Alexandre from IT. Everyone did a very tough work to put 9 people online, everything working. Fortunately, the line didn't went down anytime. So I think everyone kept the fingers crossed and it worked. Thank you very much to you all. And I hope we can meet again in the next opportunity with such a team and an exciting topic like this one. Thank you very much. We're signing off now. Thank you.